Okay, so we're going to begin a conversation following up on Professor Sandel's excellent presentation this morning at the opening session for the APA National Planning Conference. My name is Patricia Salkin. I'm a faculty member at Albany Law School, and I'm the director of the Government Law Center. And in addition to teaching land use law, I teach a course in planning ethics at the University at Albany, and have been involved for many years with APA and AICP in the study of the AICP Code of Ethics.
And I joined Patty today, a great privilege to do so. I'm Dwight Merriam. I'm a land use planner and a lawyer with a graduate degree in planning and a law degree, practicing in a large law firm, as I have for a third of a century now, hard to believe. And I'm a past president of the American Institute of Certified Planners, and been involved in these issues on many different fronts. So I am thrilled to have an opportunity to hear the professor speak this morning, and certainly the audience was so engaged. An opening a set of remarks like this, you sometimes see people wandering out after the first half hour or 45 minutes. I looked around, everybody stayed to the end. They were just thrilled. And I'd tell our viewers today that they can see these lectures of Professor Sandel free online. As he said at the opening video, they are available through WGBH online, and they are terrific lectures, and I encourage our viewers and listeners to take a look at those. I started to say beforehand, before we open the microphone here, that in doing some research on him, I found out that he is probably a character in The Simpsons. Now, I'm not a big Simpsons. Patty, do you watch The Simpsons?
I don't.
Well, apparently people believe that he is, in The Simpsons, Montgomery Burns, who owns the Springfield nuclear power plant. So I leave you to go back and watch The Simpsons.
Well, you know, Dwight, I thought that it was interesting the way that Professor Sandel opened up the session, and he talked about his theme was getting to what's the right thing to do. And he started after his hypothetical that we may go back and talk about. He did talk about different political theories, philosophical theories. And so he started with the utilitarian point of view, and he said there the right thing is whatever is going to maximize the greatest good for the greatest number of people. And I think in general, planners do have that thought in mind that somehow we're doing something for the greater good. On the other hand, he then raised some of the problems or the weaknesses with that and went to the non-utilitarian view, and he talked about one of the weaknesses with the utilitarian view is that it fails to respect individual rights. And I just want to jump right in and start with the beginning of the AICP Code of Ethics and Professional Conduct, and maybe we'll start with the aspirational section first.
Well, I think partly the question that's still on the table for me is his book is called Justice. He didn't talk so much about justice, but he talked about what is the right thing to do. And how would you say that fits in with our ethical standards? Are ethical standards, in your view, kind of the rule of law for planners to help them come to just and ethical results?
Well, I think that the AICP rules are a combination. I think that in Part A, the aspirational part of the code, it clearly is seeking out justice and trying to get to what's right for our communities. However, the second part of the code contains the rules that we'd analogize to. These are the rules that you must follow, and that's a combination of things. Some of the rules really lead us to this is how you interact with the community in the most ethical way to promote some of the kinds of civil discourse that Professor Sandel was talking about in terms of their relative importance. But then there's another part of the rules that really govern the conduct of individual planners vis-a-vis other planners and vis-a-vis the profession that maybe don't have as much obvious relationship to the community kinds of decision-making that Professor Sandel would talk about in terms of seeking justice for everybody.
So the aspirational parts of the code are just that. They're designed to inspire us to do the right thing, but they're not mandated. And the other part are real hard and fast rules that we can measure whether we perform on or not. So can you give me some examples of each?
Yeah, and I think that some of the challenges are, I think that what Professor Sandel was trying to get at are most clearly in the aspirational parts of the code, and maybe that is the most appropriate place for them, because I think he pointed out the difficulty in balancing all of these competing philosophies and balancing the environment within which we have to make decisions. So just for example, Part A of the code talks about the principles to which we aspire. Mm-hmm. And Section 1 is our overall responsibility to the public. And we jump right in, and it says that we shall always be conscious of the rights of others. Well, if we're going to be conscious of the rights of others, that was one of the weaknesses that Professor Sandel pointed out about the utilitarian point of view. But yet, on the other hand, I think somebody asked a question at the very end of the session that said, well, what would Aristotle do with our trolley scenario? And Professor Sandel did say you're not going to be happy, or satisfied with the answer, but it requires us to go forward and ask another question about who are these people? Well, that's then making value judgments, but maybe that is being conscious of the rights of others. Although, again, it creates some other tensions that we'll talk about today as well.
Well, look at this one, Patty, that really strikes me as being so on point, as if Professor Sandel had written it for our code. A1F, this is an aspirational provision. We shall seek social justice by working to expand choice and opportunity for all persons, recognizing a special responsibility to plan for the needs of the disadvantaged and to promote racial and economic integration. We shall urge the alteration of policies, institutions, and decisions that oppose such needs. That seems so in tune with what he was talking about today.
Yeah, I think that Professor Sandel might like to see that as a rule instead of as an aspiration. And of course that is part of the democratic project and part of a civil society, and making sure that all stakeholders are engaged. And I think that the point he was making is that we now live in a society where we have the haves and the have-nots, and sort of how this has really created a breakdown in the discourse. But why is it here as an aspiration if it's something that planners might agree is an ideal to achieve? And I think because we then have to layer in, it's one thing to say it's a goal, but it's another thing to figure out how exactly are we going to get there and who has authority to get us there.
Well, as Mark Twain said, always do right. This will gratify some people and astonish the rest. What about this obligation really early on in the aspirational part about our primary obligation to serve the public interest? Would you spin that out a bit?
Yeah, I think that, and the code is really based on this premise, and I think that's the reason most planners were inspired to choose this profession, because we have an opportunity to shape the community, the environment, and the quality of life for everybody around us. And so that is a public interest goal. However, the challenge again is like anything in public life or in any place where there is a government agency, people disagree on what is the public interest, what is the ideal public interest. Is it to put a housing project in one location versus another location, or to build a park in one neighborhood versus another neighborhood? There are finite resources, and we have to figure out in balancing all of this how it is that we are going to get to that ideal. And I think in the principles it says that we have to pay special attention to the interrelatedness of decisions. You can spin that in an environmental and a public health kind of perspective, or you can look at it in the sense of, if you make one decision to site something in one location, what does that do to other neighborhoods and areas? Does it build them up, or does it repress them in some way?
Well, I think the this provision in our aspirational part of the code that says, quote, "Our primary responsibility is to serve the public interest, and we therefore owe our allegiance to a conscientiously attained concept of the public interest that is formulated through continuous and open debate." And it certainly seemed that Professor Sandel was calling for that. I think what really struck me was the question, one of the questions, and the questions were terrific today, about the cul-de-sac. And it points right squarely on this issue of the constant tension. Now, I went to planning school almost 40 years ago, and we discussed it then and we discuss it today, of the planner as being a facilitator of sort of the majority view of the public versus the planner as someone who sees the needs that the public may not perceive. And his answer to that, which frankly I don't accept as a complete answer, is that the planner should serve as an educator as well. So what do you think we're meaning here by what is the public interest? On the cul-de-sac question, suppose that 65% of the people say, you know, we really like cul-de-sacs because our children can play on their bicycles in the street, but the planner knows that connectivity is really important and that our cul-de-sac and our gated communities really haven't worked. So that should the planner then impose his or her will, if I can put it in that way,
you know,
on the public?
And I think that this is where I thought that Professor Sandel actually was masterful in his response, because the bottom line is, for most of these decisions, the planners do not have the authority to make the decision. The decision is ultimately going to rest with an elected or appointed public body. It's either going to be a mayor or a supervisor or a city council or the legislative body or a planning board or a zoning board, depending upon what the issue is. The planner is supposed to inform about the pros and cons of the choices that decision makers have before them, and the planner is the conduit to get the community engaged. And that's going back to part of our social justice concepts that are both in the aspirational part of the code and in the rules, to make sure that people do come out, that people do have a role in that civic discourse, which Professor Sandel said was critically important. So where the planner believes that based on the knowledge and training and information that they have that has formed their judgment, and again, because that's part of our aspirations too, we're supposed to bring all of that to bear. Professor Sandel, I think, was realistic in his view that what we can do is not always, we can't impose our view on the public, but we can educate the public and explain to the public and listen to the public's concerns and listen to their desires and try to work with that in order to try to bring people along if we think that it should go in one direction versus another. But ultimately, you know, we have about as much influence in the process as the public might have if there's an open public participation process, and they might have more because they represent, the reality is, they represent many more votes to a city council member or to a mayor than one or two or three people in a planning staff.
Well, this goes to this aspirational principle, and I just quoted here from the code because it'll, I think, shed some light on this. Quote, "We owe diligent, creative, and competent performance of the work we do in pursuit of our client or employer's interests. Such performance, however, shall always be consistent with our faithful service to the public interest." And the problem that I have, Patty, with the idea that, you know, at some final vote of a legislative authority or a board, is that really a central issue for planners is who are their constituents? Is it just the people in the community where they're employed or with which they're consulting? Is it the regions? Who gives voice? I think back to Paul Davidoff and Linda Davidoff in their seminal article on advocacy planning that most planners still read today, about planners as advocates for people who have no voice. If you want to open up the suburbs, who's going to speak for the people who would move there, and who speaks for future generations not yet born? And I think that's what this aspirational part of our code does address, is that this notion of faithful service to the public interest. So what are we to do when our view as professional planners of the public interest is contrary to our employer's will.
Right, and that's why it's not in the rules, and that's why the rules say that we have to also represent our clients' interests. And I think, taking the public interest, again, that is aspirational, it's idealistic, it's why we've gone into the planning profession, why many lawyers go into the legal profession, why people run for public office. But the bottom line is, in trying to define that phrase, the public interest, we don't always agree on what the public interest is. Yeah. And you can get a room full of planners together and say, here's the scenario, what do you think is in the public interest? And you'll get more than one and maybe more than 2 or 3 different answers or ideas on how to best meet that public interest. And I think that this goes back to Professor Sandel's point that we've done our job if we have facilitated the public discourse. And at some level, I'm going to extrapolate a little bit, at some level you have to say that if we can be facilitators and educators, if we can bring, as the code tells us, you have to bring honest and truthful information, and you have to put all of the facts on the table and all of the information that's known, and allow people to digest it, help people to understand it, and encourage a conversation about it, which doesn't always mean that people with power, people that are wealthy, people that vote, that they might not have the upper hand. And I think that's where we have to go out of our way into one of the sections of the code where it talks about social justice and it talks about engaging the community. Planners sometimes have to go out of their way to bring people into the process who might traditionally be disempowered or who might not feel that their participation is welcome into the process. And it might not be enough to just satisfy legal public notice requirements in a newspaper of general circulation that says we're having a community charrette, or we're going to talk about this comprehensive plan, or we're going to talk about an amendment to the zoning ordinance that's going to impact a neighborhood and nobody from that neighborhood is there. Mm-hmm. And so I think that that's our job, to go out and find people from the community who might be impacted positively or negatively and bring them into that civic discourse.
Well, I think inevitably planners are going to find themselves pushed and pulled in various ways, and although Professor Sandel didn't speak to this, I think it's important for us in this commentary to take a look at Code A2C, which is something that you've written a lot about, and that is, we shall avoid a conflict of interest or even the appearance of a conflict of interest in accepting assignments from clients or employers. Although his talk, of course, had to do with justice and ethics and finding the right thing, I think in finding the right way, we have to be ever vigilant to the potential for conflicts.
Yeah, the conflicts are always going to be there, and I think that's why looking at our rules of conduct, which is Part B of the code, and making sure that as planners we are abiding by those while seeking to satisfy the aspirational goals in Part A is what's going to serve us well. So let me give you some examples from our rules of conduct that I think would be important. We shall not deliberately or with reckless indifference fail to provide adequate, timely, clear, and accurate information on planning issues. That's how it starts, B1.
That's a rule of conduct which is mandatory, enforceable, measurable,
correct,
and can result in a disciplinary action against a certified planner, correct?
Absolutely. And I think part of that is making sure that you can have this full civic discourse and that all of the information is out there on the table and available to everybody. And the same thing, I'm going to jump down to making sure that the conversation is in the public arena. Numbers 8 and 9 of the code, I think, talk more about these private conversations that people might assume happens in a political environment. We shall not, as public officials or employees, engage in private communications with planning process participants if the discussions relate to a matter over which we have authority to make a binding final determination, if such private communications are prohibited by law or by agency rules, procedures, or customs. And the next one is, We shall not engage in private discussions with decision makers in the planning process in any manner prohibited by law or by agency rules, procedures, or custom. And I think, again, this is sunshine. Bring everybody into the process. Don't have conversations with some and not with others, because that undermines the process. That creates a situation where people feel that they are disenfranchised. People then will not want to participate in the civic discourse that Professor Sandel, reiterates the critical importance of.
Well, this. Whenever we get to this part of the code, we typically have a very lively discussion with planners, particularly consulting planners, and in those jurisdictions where they don't have the sort of decisional infrastructure that would help them. And what I mean by this is there is an awful lot of decision making that goes on with a wink and a nod, pull on an earlobe, if you could only give us this, that sort of thing. And good things often result. I knew a planner, long since deceased now, who simply told the developer clients, look, you got to come up with 20% affordable housing, or there's no way we're going to get your project approved. There's nothing in the law that allowed him to do that. He had these private conversations with developers when they came in his office. He got the affordable housing. I think the solution is development agreements and impact fees and open processes, but most jurisdictions don't have those. So what is the town or county planner to do, or the consulting planner, when they're faced with this sort of informal process?
Yeah, I think that, again, part of that informal process is informed from the political environment within which the planner works, and that there are articulated goals from the community that ought to be in the comprehensive plan, that we need more affordable housing, or we want to encourage certain kinds of development in the community, or it may be in the elected officials, the mayor or the county executive's platform that they were elected on, that they want to prevent certain kinds of development, or they want to encourage other kinds of projects or economic development in the community. So again, there are things that planners or planning staff can suggest and begin a negotiation with developers, but the bottom line is the planning director doesn't make the decision on final approval of the project. It's going to another board, or it's going to an elected decision-making body, depending upon the nature of the proposed project. And so really the planner is the facilitator, and sometimes the planner misjudges things, or sometimes the community might say the planner didn't get enough, or the community might say in a public discourse, we want something different.
Well, I think your comments just now make me think that what Professor Sandel was talking about in the cul-de-sac question is that the role of the planner is educator. I think it's incumbent on planners, when they see these informal approaches to decision making, that they feel uncomfortable with them. You've heard me say this before, so I can say that the ethical standard that I often apply when I can't find a clear rule is simply the light of day test. And that is, if what I was doing saw the light of day, which I used to measure by the front page of the newspaper, but now since the newspapers are not that in evidence, but the light of day test is, if all your peers knew what you were doing, how would you feel about it? If you have that secret meeting, that confidential meeting with the developer applicant or the neighborhood group that wants to get something out of the developer, then, and if that were on the local blog, how would you feel about it? If you would be completely uncomfortable, then that's when you have to raise your hand and say, I've got a problem here. But I think planners, when they see this going on in their jurisdictions, the educational role that they can play is to bring it to the attention of their local politicians and suggest changes in processes and techniques, pre-application hearings, and as I said, development agreements or other open processes by which negotiation can occur, and do that in their educational role. And we don't see planners doing that much of that. And that seems to me a good way to solve some of those problems. The business, if I could back up one step, Patty, to what you said about the planner's obligation to provide full information.
Yep.
I think this is a very difficult situation for particularly consulting planners who may be engaged by a developer or a developer's lawyer, particularly if they're engaged by the lawyer and then they're under the attorney-client work product privilege. And just here's a real-world example. We had an environmental consultant take a look at a site, and the environmental consultant came back and said, you know, you're okay, we don't have that particular plant species that we thought might be on the site, but we found another one that nobody knew we had, and it's an endangered species. And it probably doesn't affect your development, but I think we have a legal, moral, and ethical obligation to report to the state that we found an endangered species on your site. Now, what happens if the developer says, you're going to destroy my project or you're going to ruin the value of my property? Fortunately, we had an enlightened developer in that case, and he did the right thing. And he said, and maybe I wouldn't be telling the story if he didn't, but and he said, go ahead and tell him.
But, you know, I
So what
think
happens
that,
when a planner comes across some information like that that could be very damaging, whether it's the municipality or the developer or the neighborhood group, and the client says, I don't want you to put that in the presentation.
You know, I think that we have a responsibility. Again, this is getting to doing the right thing and to putting out accurate information. And I think it's also our job to talk with that client and explain, and maybe be a little bit of a creative problem solver here, explain how they might come out better by addressing that up front. Because if they don't address it up front, you also do take the risk, ethics aside, you take the risk that it's going to be developed, it's going to be discovered partway through after there's been an even more significant investment of resources. And, you know, we're both lawyers. It's no different than our obligation to the court to put up the case law that is opposite of our client's point of view. And it's our job to argue why that case should not be applied here. But we're not supposed to hide it from the court.
Right.
We're supposed to acknowledge its existence.
Well, after this incident I just related to you, my advice, my policy, and my own policy, and my advice to others is that every consultation have a written contract, just like lawyers are required to have a written retainer agreement, and that the contract address the issue of the discovery of such information and what will be done with it. Mm-hmm. Because the consultant may not only have an ethical and moral obligation to reveal, but he or she may have a legal obligation to reveal. And they better be upfront about that with the people that are engaging them. And I would say the same with a municipal or county planner, that their terms of engagement ought to address the issue of what they're going to do with this unexpected discovered information that may be of interest to others. And if you get it out front, and the final thing is, one thing we learned as lawyers that we see some discussion among the planners, and that's the so-called noisy withdrawal. The noisy withdrawal for lawyers is that if you think that you're in an ethical bind, you negotiate with your client, try to resolve it. If you can't, then you have to decide how to withdraw, and you can withdraw quietly, resign, quit, not work anymore on it, or you can do a noisy withdrawal, which is basically telling others, including a court, for example, that you have an ethical problem and you have to resign. So what advice do we have for planners on that based on our code, both aspirational and the rules?
Well, you know, again, I think that the code does seek fairness, and it does require planners to be honest and to be forthcoming with information. And I think having that conversation with your clients up front, as you do, and maybe getting to that written agreement, is critically important. I wanted to just jump over to one other issue, because I thought Professor Sandel talked a lot about how the civic discourse could be undermined, and particularly in cities. He did spend some time emphasizing the difference between economic injustices or differences, the poor and the wealthy, which may or may not get into other kinds of ethnic kinds of divides in communities. And he talked about the differences in schools and in parks and libraries and different kinds of public facilities. And one of the rules that planners are supposed to follow in the AICP code says, number 20, we shall not unlawfully discriminate against another person. And I'm wondering how this fits in to the whole concept of the democratic project and the civic discourse. And, you know, the language is very specific. We shall not unlawfully discriminate.
Right.
And I'm not sure that planners really get the full flavor of what does the word unlawful mean. But let's put that aside for a minute and let's just talk about discrimination. Because there are lots of civil rights laws that come in many forms that planners have to deal with, Fair Housing Acts, ADA, and so forth. The list could go on. But if we just eliminate the word unlawful for a second and just talk about discrimination, doesn't that get to civic engagement and who's at the table and who has access to what information and what points of view are being considered, and then getting to the final answer of what's the right thing in the public interest? Is the public interest all of the communities and all of the smaller communities within the larger city? Or, you know, how do you do this? Do you base it on demographics? Do you base it on census data? I mean, how are you defining, again, the public interest to make sure that we're not unlawfully discriminating against somebody?
Well, whether the word unlawful is in there or not makes an enormous difference, and planners have enough problems with the unlawful discrimination. You certainly, and you just touched on it, but I have to highlight the Fair Housing Act, Fair Housing Amendments Act, and group homes for all types of disadvantaged individuals, generally those within the reach of the Americans with Disabilities Act, and I'm talking about recovery residences for people in recovery of alcohol and substance abuse, but also physically disabled and mentally challenged adults. Enormous issues, and for planners, really the difficult problem is whether you concentrate or separate them. And most importantly, in my judgment, very troubling is how do you do discretionary reviews without shining a light on these folks who deserve to be treated like anybody else? In other words, do you use a conditional use or special permit for a group home? And the answer among the courts is about half of them say, no, you shouldn't. But how does a planner really shape what decisions are being made as to where they live? I think our absolute biggest problem, which is probably not reached with the term unlawful, is the definition of family. Mm-hmm. We are discriminating against people who choose to live together without being married, extended gay and lesbian families, and many others. Even one state, a famous case about the 7 nuns, in an article I wrote later called the 7-Nun Conundrum. 7 nuns can't live together. The definition of family, persons related by blood, marriage, or adoption. But if you remove the term unlawful and talk about the broader issues of discrimination, I think our biggest problem right now is some of the decision-making processes that we have and whether they discriminate inherently. I mean, I've seen the battle on both sides about charrettes. Mm-hmm. You know, charrettes are those highly intense, several-day design workshops intended to yield a development plan and regulations at the end of the process. Some people love them. Some people think they are the worst thing going because they concentrate the most verbal, the most powerful, the most moneyed interests in directing a plan that is virtually imposed on the community. So I think planners need to step back on this one and consider the processes that lead them to their decision making.
Well, because in order to get to fairness and justice, you know, that doesn't mean that everybody walks out a winner. And how somebody views themselves as a winner or a loser is kind of subjective.
Well, the professor said we need to reflect on what we want in public settings. Less privatized, more for common purposes. This is when he finally got to Aristotle. But when we have big public meetings, who shows up? You know, the people with the time and the money. Who's working the issues behind the scenes? The people who want to influence the policy and have the money. Mm-hmm. Who's tweeting and on the web the people that have the technological skills. There's an enormous groups of people who are simply excluded from the process because they don't have a computer and they don't know how to manipulate that part of it.
So how can the planner speak for those that are not speaking if the planner doesn't know exactly what they want?
I don't have a pat answer for that. What I say is that we need to be sensitive to the reality that our decision-making processes and structure is inherently discriminatory in many aspects. Maybe not so that it's dysfunctional and shouldn't be used, but the planners ought to be saying, who isn't involved in this process? Who's not here? Who's not speaking? Whose voice isn't being heard? Where we pretty much ended this morning's opening remarks by Professor Sandel was with his use of the word skyboxification, which I just thought was pretty terrific. And it really encapsulates a very large issue for all of us in terms of social justice, ethics, morality, and what we do as planners, and that is the privatization of what has been public functions. And everybody should go back and listen again to what he had to say in that regard of what our obligations are as planners to invest more, if you will. He talked about highway investment and what that resulted in, many unintended consequences. And now he called for a time of investment in public, physical, and institutional infrastructure to return people to what I characterize as the common weal, the place where people come together and interact. And I think that is a great call for all planners going forward, Patty.
Yep, Dwight, I agree. It certainly is a great call and something that I would put in the category of principles that we should all aspire to, figuring out how to accomplish that in what Professor Sandel explained as a climate that is so dominated by market forces. And so I think, again, going back to where he started, in justice, we as planners have to figure out what is the right thing to do and what is our role in getting to justice in the profession and for our communities.